Now back to the show. This is The Law Show on CL 650.
That's Elton John. I know that's Elton John singing with, I've been told, Lady Gaga, because those two mix so perfectly together. We're here on The Law Show on CL 650. We're talking with John Lakes and John White, partners at LakesWhyteLLP North Vancouver law firm, experienced in estate planning and estate litigation. And today we're talking about the basic rules. And we have two Johns here, so you must get confused all the time when you're partners, which one has the right last name. And names are very important, obviously, on legal documents when you're talking about your will. So this came to my attention because my wife and I, we don't have our middle names on our mortgage. And somebody pointed that out one time when we were renewing a mortgage, that could be an issue down the road. Can you explain, when you're talking about the names on documents for your will, that you have to get it right and do a double check?
Well, the thing is, when you die and eventually letters probate are going to be issued, the letters probate are going to be sent to various authorities, and it's also going to be how they'll be able to deal with your land. And therefore, if your name appears differently in the legal document compared to your will, it could create a problem where your executor will have to prepare necessary documents to prove that you are the same person. So a typical example, like the house, how you deal with the house is either when you do a will, you could either get your title cleared up where you add your middle name, or else when you do a will, you say so-and-so also known as. It's much more common when a woman remarries, where she's changed her last name, so in a will it may need to say Mary Ann Wilson, also formerly known as Mary Ann Smith. Mm-hmm. Or else sometimes when people have emigrated to Canada from somewhere else, where they may anglicize their name, so their real name may be Lakowski, but they call themselves Lewis here. Then again, in the document, what you need to do is you have so-and-so also known as so-and-so, or either that, or as in the process of doing the will, try to clarify all your legal documents so everything appears in the same name.
Mm-hmm. It seems kind of basic, but it's that's the stuff that people miss, right?
It can be a big deal too, especially if you have a relatively common last name, because people are worried about fraud all the time, and if your driver's license and your passports have different names from your legal documents, it can create a bit of confusion.
So we talked about the executor before the break and what you're looking for in the person that's going to look after your estate once you're gone. What's the job they have to do? Because we talked about it being an honor and a duty, and it might be an honor, but it certainly is a duty. What are the duties?
Well, they have to basically have the will recognized by the courts, be recognized, then obtain letters probate, and then process with carrying out the will the testator's intention according to the will. So they have quite a lot of jobs. I mean, first of all, they have to make sure the document they have is the last will and testament, and make sure there's no testamentary documents like a PS to other assets. They have to determine who the beneficiaries are. So if it's somebody who, your brother or sister, they usually know who all your children are. But if you're in a circumstance where you don't have children, there's an issue who nieces and nephews are and things like that. So
on the other side, you write the wills for people, you help them with their estate planning, but you're also doing this with the executors too. You help them stick handle all this stuff too.
And hopefully they have all the information, because they have to, when they apply for probate, they have to send a copy of the will, first of all, to everybody named in the will. And second of all, they'll have to send a copy of the will to anyone who may have a claim under the will. So that would be the closest blood relatives. So if you have 3 nieces, and in your will you're only naming 2 nieces as beneficiaries, you still have to send a notice to the 3rd niece. So it's quite an important job. And so, as Winston Churchill said, you can't do the job without the tools. So when you appoint someone an executor, you need to give them the information as well. So you need to give them a family tree. You need to tell them who these beneficiaries are and where to find them as well. You have to determine, the executor has to determine the person's assets and debts. Now, In the old days, and for certain people, everything would come in the mail, so you could rely on, especially this time of year, all the T4s and T5s coming in. But you've got a whole generation now of people do everything electronically.
Mm-hmm.
And there's now a problem of how do you get that information, because if you can't find all the passwords,
right,
then you end up. There was an interesting article about a woman on CBC last week who was having problems accessing her husband's passwords onto the computer. Now, you can sometimes get somebody from the Geek Squad or somewhere coming in and crash that information, but I mean, getting the information is getting more difficult. So you have to gather up this information, notify everybody, and then go through this whole process of obtaining letters probate, which is you then are on first base. So you can now deal with the assets, and which means you've got to deal with all the disposing of assets, paying off debts, dealing with CRA, Canadian, and because you have to do all final tax returns, get a clearance certificate, deal with litigation if somebody's suing the will based on the fact that they think it's unfair or there's some lack of clarity in the will. And eventually you have to prepare an accounting for the approval of all the beneficiaries, which says, the money they collected, the money they paid out, and the beneficiaries have to prove that. And if the beneficiaries don't approve that, then the accounts are approved by court. So it's, typical estate probably takes 2 years to get everything wound up.
And John, you're on the side where you have to go to court and sort these things out. So where does it typically go sideways? Can you give us some examples?
Well, sure. I mean, there's a couple of obvious categories. I mean, there is the executor who doesn't do enough to discharge the duties that John has just taken you through. And then there are a number of cases where the executor does way, way too much, goes way beyond what they're supposed to do. An example of the former is actually the leading case in this area. It's a decision from the Supreme Court of Canada back in 1977 called Fales and Canada Permanent Trust. And here's a case where Canada Permanent, which I forget what they are now, they've merged more than once, was the one of two executors of about a $250,000 estate. It was probably a little more than that, actually. It consisted almost entirely of shares in a small company. It was a pretty solid small company. And what they did is they exchanged those shares basically for shares in a larger company, and there was nothing wrong with doing that at the time. But what happens thereafter is the larger company starts to go downhill slowly at first and then more rapidly. And the executors don't unload the shares. They continue to hold on to the shares. They don't really look seriously at whether they should be unloading the shares or not. And by the time they finally manage to sell the shares, the estate has lost, as the Supreme Court of Canada wound up finding, $250,000, which back in 1977, or really back in 1969 when this was actually happening, because it took that long to get to court, that was a lot more money than it is today. And the Supreme Court of Canada was quite critical of the institutional executor, Canada Permanent Trust.
So this wasn't an individual. This was an institution that was looking after the money.
Well, there was an individual executor as well.
Right.
But the
So what did the court find?
Well, the court found essentially that they should have got rid of those shares a long time before they did. They should have investigated more carefully whether they should be selling the shares. And they should have just paid more attention to the file is really what it comes down to. And so they were required to reimburse the estate for that huge loss. Now, I said there was a personal executor as well. She was the widow of the deceased. She had much less of a day-to-day role in making the decisions. The trust company was a professional organization. Arguably, she was part of the problem, too. She didn't sell the shares either. But there is a provision in our Trustee Act, what then was Section 98, it's now Section 96, which allows the court to excuse an executor who causes a loss where they've acted honestly and reasonably. It's
Is that someone basically who's in over their head?
Yeah, well, yeah, somebody who's in over their head and really although they've caused a loss, they didn't act unreasonably.
Mm-hmm.
And the Supreme Court of Canada, at the end of the day, found that the widow had not acted unreasonably, and certainly hadn't acted in any way dishonestly, but found that the trust company had acted unreasonably,
mm-hmm.
and that was the
so
distinction.
they put the blame on this.
Oh yes, yeah. Oh very much so. That's an example, and there are many other examples where the executor doesn't do their job, or just doesn't do their job appropriately.
Is it your advice if you have an estate that comes through and there's lots of stocks and shares and things, is to liquefy them so that there's no question you don't get caught in this situation where they go down, like say you own Northern Telecom and it goes down to zero?
Well, that's an interesting point, because sometimes in preparing the will, you can do special clauses there, because sometimes, generally the type of investments you have are supposed to be pretty conservative.
Mm-hmm.
But sometimes somebody may have stock options, or they may be in a speculative company where...
Yeah, but Nortel was considered a blue chip company.
Yeah, Nortel set me back like almost every other Canadian. So, you can put provisions in there. That's...
Yeah.
As to you're not supposed to put anything that's speculative, but you can put provisions in there.
What it boils down to is this, is that you are expected, and this is a standard that goes way back to the 19th century, you're expected as executor to administer the trust assets to the standard of a person of ordinary prudence managing their own affairs.
So common sense, basically.
Common sense.
Yeah. Yeah.
So, if you have Nortel, at one point, it would not have offended common sense to hold on to Nortel shares. Later on, and it offended common sense to hold on to Nortel shares.
Yeah.
You've got to pay attention. You've got to keep your eye on the ball, because you are, as executor, dealing ultimately with somebody else's money.
Yeah, and it should be, it's maybe not job one in your life, but it should be high up there, right?
Well, this is why you need to select the right person, someone who's capable of doing that job.
All right, we're on the Law Show. We're talking about a fascinating subject. There's so many different tangents you can go off, and that's probably why your business is so interesting. We're with the Law Show here on CL 650. John Lakes, John White from LakesWhyteLLP in North Vancouver will continue next here on CL 650.
There's more of the show still ahead. This is the Law Show on CL 650.